Okay, welcome back to another episode of Intellectual Property, in which we're going to be discussing the process of patent claim construction. This is a really profoundly important aspect of patent litigation and of understanding how patents work, because what we're going to be talking about today is understanding how courts determine the meaning of patent claims. And as I mentioned in our previous episode and in our class, right, the patent claims are the critical part, or rather the most critical part of a patent, because they define the scope of the exclusive rights of the patent. In other words, the claims describe the scope of the property interest that's granted by the patent. Now, in order to understand the claims, it has to be interpreted in light of the specification or the description of the invention itself. In other words, courts are going to look at the patent claims, they're going to interpret the patent claims, and they're going to do so in light of the way the specification describes the invention and defines the various terms in relation to the invention. And they're going to do all of this through the lens of a person having ordinary skill in the art, a thosita, a person who knows about the area of activity or the area of invention that's at stake. Okay, so it's a kind of from a patent applicant's perspective, as we mentioned in class, they've kind of got competing incentives, right? Because on one level, because the patent claims are going to define the scope of the invention, the patent applicant or the patent owner wants the claims to be as broad as possible. But then at the same time, right, they're concerned that the patent claims are too broad, then they might be harder to defend. So in some cases, a narrower patent claim may actually be stronger, right, because it's going to claim less stuff and be harder for a defendant to invalidate, but only if the claim still reads on to the invention. So the narrower claim is going to be stronger and harder to defend, but also less likely to be infringed. And the broader claim is going to be much more likely to be infringed, but also a lot harder to defend. So there's a lot of kind of competing incentives here, and we'll think about that as we discuss the patent application process. Okay, well, the first question in any patent infringement action is determining what the patent actually protects, right? What does the patent actually claim? Right? What's the scope of the claim, and how should that claim be interpreted? And that process requires what's referred to as claim construction, right? In other words, the court has to sit down and determine what the meaning of the claim is on the basis of the language of the claim as well as the specification. And they do this in something called a Markman hearing, right? So Markman was a case decided by the Supreme Court, and in that case, the court said, look, this process of claim construction is something that happens prior to the actual infringement litigation, or it's the first step in an infringement action, and it's something that's decided by the court. Right? So it's primarily a question of law, although, as we'll see, it can also have factual elements implicated in it. And the Markman hearing is really, really important because oftentimes it's decisive to the outcome of patent litigation. Right? In other words, oftentimes in patent litigation, the only real live question is what the patent actually covers. And once you know what the patent actually covers, then you also know whether or not the alleged product or the allegedly infringing product actually reads on the patent, or rather whether the patent actually reads on the product and whether the product is infringing. So frequently, the Markman hearing will kind of basically wrap up the entire case insofar as the court's deciding whether or not the patent actually reads on the product in the first place. So as I mentioned, right, there is an open question as to whether there was an open question as to how to interpret Markman in relation to claim construction, and whether to think about it as a question of fact or a question of law. So in Teva Pharmaceuticals v. Sandoz, Teva owned a patent on a drug called Copaxone, and the relevant claim in the patent described an ingredient having a molecular weight of somewhere between 5 to 9 kilodaltons. And Teva said, Sandoz, your drug is infringing on our patent because, among other things, it includes all of the elements of the claim, including that one. And Sandoz's primary defense was, look, the claim in question is not sufficiently definite to be protected as a patent claim because Teva didn't sufficiently explain what they meant by that molecular weight. I mean, after all, there's multiple ways of understanding what it would mean for that element, for that ingredient, to have a molecular weight of 5 to 9 kilodaltons. And Sandoz specifically points to 3 different potential meanings that might have. Now, the district court ruled in favor of Teva, saying, no, it is sufficiently definite because a Fazita would know that the first one is the one that we would normally use in the field. In other words, sure, there's lots of different ways of discussing it, but from the perspective of a Fazita, obviously the first one is the one that would be used. That's standard within the field. Therefore, even though the other 2 are possible, right, they're not ones that a Fazita would use, and therefore the claim is sufficiently definite. The Federal Circuit reversed as a matter of law, saying that it was not sufficiently definite, and therefore the patent claim couldn't stand. And the Supreme Court reversed again, saying it's kind of a split question. Right? So the Supreme Court said, look, there is a question of fact here. The question of fact is how a Fazita would interpret the claim, right? And nevertheless, once the court knows or has decided that question of fact, it's then a question of law what the patent claim actually means, right? So there's both factual and legal questions implicated in the claim construction process. We have to know what a Fazita would actually do, and then once the court has the relevant information, the court has to read the patent claim in light of the language of the claim and the claim specifications. Okay, so let's move on to discuss the T-Shot v. Green Mountain case. So what did that involve, right? In T-Shot v. Green Mountain, T-Shot has a patent on essentially a teapot, right? It's like a K-cup, like a Keurig cup that's used for brewing tea. And the idea was that, well, we're going to, teach a method of ensuring that you can make a cup, a K-pod, or a tea brewing pod of this kind that's going to produce a reasonably strong tea, even though it isn't going to be brewing for a very long period of time. And the key question is whether the product in question, whether the patent actually read on the product in question. And the argument was over whether this term water permeable actually applied to a K-cup, right? So the patent in question came with some illustrations, which you can see here. Essentially, the patent seems to claim tea bags in a container, right? And Keurig said, look, the language of the patent goes to a sealed body constructed of a water permeable material, which sure looks like paper or something along those lines. And it said, look, a K-cup is not constructed out of water permeable materials made out of plastic with foil on top, right? And in particular, the foil is not water permeable, right? The water only goes through the foil when you poke a hole in it, right? And T-Shot said, nope, that's water permeable, right? Once you make the hole, water permeates, therefore water permeable is satisfied. Federal Circuit says no, right? Plain meaning of water permeable means that water can always go through it, not that water can go through it when you make a hole in it, because water can go through anything when you make a hole in it. The Federal Circuit says, look, under the plain meaning of the language of the patent, the material in question has to be water permeable at all times, not water permeable when you punch a hole in it. Therefore, we're going to construe this more narrowly and in effect saying that the patent claim doesn't read onto the product, and presto, the case is over. Okay. What happens then and here you can see the punctured foil lid and so on of the K-cup in question, not water permeable, and certainly not even semi-similar to the patent in question. Okay, so what happened then in the Nautilus v. Biosig case? Well, Biosig owned a patent on a heart monitor that was based on using spaced electrodes in order to eliminate interference and provide a better record of the exercise machine users' heart rate. And essentially, BioSig said, look, we provided information about this invention to Nautilus, and then Nautilus went and incorporated it into their machines without licensing a patent from us. They've infringed on our patent by doing that, and therefore they owe us damages. And Nautilus responded essentially, no, this patent is no good. It's invalid because it's indefinite. And their argument is, look, the patent says that the electrodes have to have a space relationship, but it doesn't say what that relationship should be, right? It just says they should be spaced, and you should space them in some way, but it doesn't say how the spacing is actually, what the spacing is actually going to be, or even how you would determine what the spacing is going to be. And the Federal Circuit said, no, that's good enough, right? Because a Fozita, a person who worked in the area, would, they could figure out based on trial and error what that spacing would be. And the patent in question is sufficiently definite because, you can interpret it. It's like possible to come up with an interpretation that would convey information about what the patent is claiming. That's good enough for the purpose of claim definiteness. SCOTUS then reverses, right? And it says, look, no, that's not enough. Right? The standard is higher than that. It has to be more definite than simply saying they're in a relationship without specifying what the relationship is. That's not enough in and of itself to be sufficiently definite. And Federal Circuit, you should review this case and determine under the circumstances whether the patent claim in question would actually convey to a Fozita what that relationship would be based on the language of the claim and the specification. Okay, then what happened in the Pacingtex v. Garmin International case? Well, here we have a situation where Pacingtex has a patent on a playback device that can be used for pacing exercise. Garmin, which you may be familiar with, is in relation to their exercise products. They come out with their own exercise pacing device, and Pacingtex says, look, our patent reads onto your device, therefore it's infringing and you owe us damages. Garmin says no, right? Because your pacing device refers to a playback device, right? Now the claim itself doesn't specify what a playback device is, but the specification does. In the specification for the patent, the specification makes it very clear that playback device for the purpose of the Pacingtex claim means a device that plays back some sort of like sensible or perceivable element that's going to convey information about the pace to a user. In other words, it makes a sound, or it flashes a light or something like that conveys information about the pace to a user. Now, the Garmin device conveys information about pacing, but it doesn't do so with sound. It doesn't do so with light. It's just displaying information about the pace that the user is exercising at. That isn't something that the patent reads onto because the specification and the definition of playback device in the specification informs the meaning of the claim, right? In other words, the patent applicant or patent owner can act as their own lexicographer, as the court puts it. They can define what terms mean in the specification of the patent, and the court has to use those defined terms in order to understand what the patent claims mean. In other words, by virtue of defining a playback device in the specification for the patent, Pacingtex effectively limited the scope of the patent claim itself, even though the plain meaning of the words in the claim didn't limit the scope of the patent claim. The specification read in conjunction with the claims did, because the specification made it clear that playback device meant something more than just a device that plays back anything, but that it specifically means a device that plays back some sort of sensible information, right? So this helps us understand what courts have to do in order to construct a claim, they not only have to look to the plain language of the claim itself, they have to read the plain language of the claim in light of the definitions for the terms that are provided in the specification.